9 o'clock has arrived, and we'll call this meeting of the Pennsylvania State Ethics Commission meeting to order. Pursuant to the requirements of the Sunshine Act, the holding of an executive session must be announced at the public meeting immediately prior to said executive session or at the next meeting thereafter. An executive committee meeting of this commission was held on May 5th, 2015 to review matters that are by statute, 65 Pennsylvania Consolidated Statute, sections 708 and 1108, confidential, including the review of completed investigations for the purpose of issuing final adjudications, the review and consideration of applications for 90-day extensions of investigations filed by the investigative division, and the consideration of the assigned reviewing commissioner's recommendation to terminate certain preliminary inquiries. An executive teleconference meeting was held on March 6, 2015 to review matters that are by statute, 65 Pennsylvania Consolidated Statutes, sections 708 and 1107, confidential, including the review and consideration of applications for 90-day extensions of investigations filed by the investigative division, and the consideration of the assigned reviewing commissioner's recommendation to terminate certain preliminary inquiries. Pursuant to the Public Official and Employee Ethics Act, Act 170 of 1978, as amended by Act 9 of 1989, and amended by Act 93 of 1998, the Ethics Commission is specifically mandated to hold at least 2 public hearings each year, of which at least one shall be held in Harrisburg, and at least one shall be held in a location other than Harrisburg, to specifically seek input from persons and organizations who represent any individuals subject to the provisions of this Act, and from other interested parties. We have placed on the agenda for today's public meeting a notice that the Commission will be meeting today in part to receive the input or testimony from said individuals pursuant to the provisions of the law. As our previously published notice has indicated, the Commission will request copies of any statement that is presented. The individuals presenting statements before the Commission will be allocated 15 minutes in order to complete their statements. Statements shall be uninterrupted, except that such statements may be interrupted or terminated by the presiding officer if it is determined that the statement is impertinent, scandalous, or otherwise improper. And from that, we will move to our agenda for today. And the first item on the agenda is approval of the minutes of the January 28, 2015 public meeting.
So move.
Moved by Commissioner Nick that the minutes be approved. Is there a second?
Second.
Seconded by Commissioner Lewis. All those in favor will signify by saying aye. Those opposed, no. The ayes have it, and the motion is carried.
Mr. Chairman, could I take 1 second? I'd just like to commend Heather on the minutes because she does a nice job. Our minutes are not always easy to do, and I can't remember when we've ever made a correction or change to it. So thank you. You do a good job.
Yes, agreed. Item number 2 is the approval of the March 6, 2015 public teleconference minutes meeting. Do I hear a motion to approve those minutes? Commissioner DePalma moves. Is there a second?
Second.
Seconded by Commissioner Feely. All those in favor give their consent by saying aye.
Aye.
Those opposed, no. The minutes stand approved. Item number 3, we have civil penalty orders consent agreements this morning. Commissioner DePalma.
Thank you, Mr. Chairman. There are 2 civil penalty cases with proposed consent agreements that are now before this commission for decision. These cases involve respondents Andrea Walling and Mike Pearson. The parties have submitted consent agreements proposing that the commission find that the respective respondent failed to timely file 1 or more complete and accurate statements of financial interest and impose 1 or more civil penalties. Respondent Walling has not paid the settlement amount agreed to by the parties for the consent agreement in her case. Respondent Pearson has paid the settlement agreement amount agreed to by the parties for the consent agreement in his case. In each case, the respondent has filed a delinquent form or forms. Based upon my review of the facts, I am of the opinion that these consent agreements are consistent with the Commission precedent and are proper dispositions for these cases. It is my opinion that the Commission should order Respondent Walling to pay the recommended civil penalty agreed to by the parties for the consent agreement. Based upon my analysis and comments, I would like to make the following motion. I move that the Commission approve the consent agreements submitted by each of the following respondents and the investigative division imposing civil penalties for failure to timely file the statements of financial interest as follows. Number 1, Andrea Walling, $250 for calendar year 2013, and number 2, Mike Pearson, a total of $500 for calendar years 2011 and 2012. Further, Respondent Walling shall be ordered to pay the recommended civil penalty agreed to by the parties per the consent agreement within 30 days of the issuance of the Commission's order.
On the motion by Commissioner De Palma, is there a second?
Second.
Seconded by Commissioner Lewis. On the motion, is there any discussion? All those in favor will signify by saying aye.
Aye.
Opposed? The consent agreements are adopted. Thank you. Number 4 on the agenda is civil penalty orders by default. And again, Commissioner De Palma.
Thank you, Mr. Chairman. There is one civil penalty default case that is now before this Commission for decision. This case involves Respondent Richard Seddon, who failed to file a statement of financial interest for calendar year 2013. The Respondent did not take action or respond to the civil penalty proceedings. Following review, it is my opinion that as to the Respondent, the Commission should levy a maximum penalty, civil penalty of $250 for the delinquent statement of financial interest. It is my opinion that the Commission should also order the Respondent to file his delinquent statement of financial interest. There is nothing of record that would constitute a defense or excuse for his noncompliance. Based upon my analysis and comments, I would like to make the following motion. I move that the Commission levy a maximum civil penalty in the amount of $250 against Respondent Richard Seddon for failing to file a statement of financial interest for calendar year 2013. Further, the Respondent shall be ordered to file his statement of financial interest for calendar year 2013 within 30 days of issuance of the Commission's order.
On the motion by Commissioner De Palma on this civil penalty order, is there a second?
Second.
Seconded by Commissioner Feely. Any discussion? All those in favor of the motion signify please by saying aye.
Aye.
Opposed, no. The civil penalty order motion has been adopted. Number 5 on our agenda is again a civil penalty order, this time contested. Commissioner De Palma.
Thank you, Mr. Chairman. There is one contested civil penalty case that is now before this Commission for decision. This case involves Respondent Tamisha Sledge, an income maintenance worker with the Pennsylvania Department of Public Welfare, who failed to timely file a statement of financial interest for calendar year 2013 with the Pennsylvania Department of Public Welfare. The Respondent filed the delinquent form with this Commission after civil penalties proceedings were initiated against her. The Respondent also filed an answer asserting that there were mitigating circumstances in this case such that a civil penalty should not be levied against her. Specifically, Respondent asserts that 1, the filing of her statement of financial interest for calendar year 2013 may have been untimely due to personal medical reasons and associated matters. And 2, she currently has a limited income as a result of such medical reasons. The Commission may consider mitigating factors when levying civil penalties. Mr. Chair, I suggest that we take a brief recess from the public meeting to engage in quasi-judicial deliberations in executive session before we decide this matter.
Okay, I think we will do that. Could we ask our guests to please move to the hallway, please? We're going to do some quasi-judicial deliberations here for a few minutes. Okay, returning to order, we are still dealing with the sledge matter, and the chair continues to recognize Commissioner DePalma.
Thank you, Mr. Chairman. Commission has some questions for the investigative division, and I'd ask Counsel Biddy to pose those questions to the investigative division.
The first question was whether the investigative division knows whether this respondent previously filed statements of financial interest for other calendar years.
No, we don't have any information whether she did or she didn't.
And the second question was, does the investigative division have information that would either support or in some way address the special circumstances that have been alleged by the respondent?
We had no way to corroborate what Ms. Sledge is asserting in her answer. She did come to the office, she spoke with Andy. Oh, that was the other one. Okay. No, so we don't. We just got the letter from Ms. Sledge, which explained her personal circumstances. So we have no way of independently corroborating what she said. Yeah, this wasn't an investigation. This was just done straight through the civil citation process where the letters were issued, and it was basically a default.
And recognizing that Mr. Petsu is not here, but Mr. Jasonson, your counsel also for the investigative division, the next question is whether, noting that the commission would be inclined to give this respondent 30 days to submit a note from her professional provider as to the circumstances that she has alleged, versus having a hearing that the commission could schedule sua sponte, but would be expensive and time-consuming for everyone. Would the investigative division have any objection to the commission providing Ms. Sledge with a 30-day opportunity?
No, we would have no objection.
Thank you.
Commissioner DePalma, if you want to continue with the motion.
Yes, I move that we continue the matter for our next meeting, and prior to our next meeting, if Counsel Biddy could reach out to the respondent and request the additional verification that the commission is interested in receiving in this case.
I certainly will. Thank you.
On Commissioner DePalma's motion for a continuance in this matter, is there a second to the motion?
Second.
Seconded by Commissioners Lewis and Feely. All those in favor, please signify by saying aye.
Aye.
Opposed, no. The ayes have it, the motion is carried.
I have one question, Mr. Chairman. Would that be the responsibility of the investigative division to reach out to?
No.
No, the motion was Chief Counsel Hitty would do that.
Okay.
Okay, our sixth item on the agenda today is a lobbying opinion for Mr. Peter J. Weirs. Commissioner Feely.
Thank you, Mr. Chair.
Excuse me, Mr. Chairman. Noting that this might be a matter where we end up in quasi-judicial deliberations, would it be the chair's pleasure to take any other matters ahead of that if people are here in the audience that the commission would be addressing or?
Sure. Is there anyone in the audience with an interest in any specific agenda item?
Or any other matter?
Okay, we'll continue with Mr. Weirs. Commissioner Feely.
Okay. This requester refers to himself as the Honorable Peter J. Weirs, trustee of the Roosevelt Fentman Trust for American Voters, which I will refer to as the trust. The question posed to us is whether the forms of entities encompassed within the definition of principal as set forth in section 13A03 of Pennsylvania's lobbying disclosure law would include a charitable trust, and if so, whether a charitable trust would be a principal engaged in lobbying as that term is defined in the lobbying disclosure law as a result of providing to the Senate, which the requester represents is at the Senate's written request, certain technical advice and assistance including a model code regarding anti-blight legislation. Mr. Weirs has represented that the trust is an active inter vivos charitable trust under Pennsylvania law, 20 Pennsylvania Consolidated Statutes, section 7735, and a non-exempt charitable trust under the Internal Revenue Code, 20 United States Code, section 4947A1. The trust is treated as an organization under 26 USC section 501c3. Mr. Weirs also has represented that the trust's activities are nonpartisan political in nature. Specifically, the trust seeks to protect voters' First Amendment rights as articulated in certain case law. Mr. Weirs has also represented that the trust administers as part of its property a federally registered standards development body named the National Conference of Public Officials, Inc., which I shall refer to as NCOP. According to Mr. Weirs, NCOP prepares and disseminates model codes relating and limited to government ethics, accountability, and productivity in furtherance of the trust's charitable purposes of protecting civil rights secured by law. One such model code is the Abandoned and Blighted Property Receivership Code, which I will refer to as the Model Code. Mr. Weirs indicates that the Model Code could potentially be enacted in Pennsylvania. He further states that the Model Code arose out of a December 21, 2012 written request of the Senate that the trust provide technical advice and assistance relating to issues involving Pennsylvania's current anti-blight legislation. Mr. Weirs states that such assistance would consist of nonpartisan analysis, study, and research, and would include the provision of the Model Code. Mr. Weirs explains such assistance might be provided to the Senate through a representative firm acting as an agent of the trust. He further states the agent would be required to limit its communications to the General Assembly, to enable a legislator or legislative staff assistant to form an independent opinion or conclusion. Mr. Weirs also states the agent would be prohibited from expressing any viewpoint on the Model Code unless accompanied by an advisory opinion of the trust's trustee as provided in the trust agreement and its internal operating procedures. Mr. Weirs states that these restrictions are imposed in order to satisfy the Internal Revenue Code and various Internal Revenue Service regulations to avoid the appearance that the trust would be undertaking any form of lobbying or promulgation of propaganda as defined under the Internal Revenue Code. Mr. Weirs additionally states, and I quote, "The trust normally reimburses its expenses for distribution of the Model Code by sale and copies of its Model Code, a common practice among all entities promulgating model codes, such as the American Law Institute. The Senate is under no such obligation to purchase copies of any model codes, which they are or may be considering. Under the trust agreement, paragraph 22A, which provisions at all times control, unless when not consistent with the mandatory provisions of the Uniform Trust Act, 20 Pennsylvania Consolidated Statute, section 7705, all beneficiaries are obligated to reimburse the trustee for extraordinary expenses which the beneficiaries may require the trust to incur. To what extent, if any, the Senate may direct the trustee, acting through its appointed agent, 20 Pennsylvania Consolidated Code, section 7777, to provide technical advice and assistance to the Senate, which is an additional service, cannot be ascertained until the Senate leadership determines its available options," end quote. The statement I just quoted appears in Mr. Weirs' April 22nd, 2015 email to Chief Counsel Hiddy of this commission. The trust contends that its activities would not constitute lobbying under the Internal Revenue Code and the regulations of the Internal Revenue Service. Mr. Weirs asks whether the trust's aforesaid activities would constitute lobbying as that term is defined in the lobbying disclosure law. Mr. Weirs represents to the Commission that even if the trust's activities would be deemed to constitute lobbying, as defined by the lobbying disclosure law. The trust activities up to now have been exempt from registration and reporting pursuant to Section 13A06 of the lobbying disclosure law. Finally, Mr. Weir states that the answer to his advisory request could impact the trust and trustee under federal law. Mr. Chair, I would suggest that this would be an appropriate time for any interested parties to speak on this matter.
Is there anyone here on behalf of Mr. Weirs who'd like to speak on this case? No? Let me continue, Commissioner.
Mr. Chair, I suggest that we take a brief recess from the public meeting to engage in quasi-judicial deliberations and executive session before we decide this matter.
Okay, I'm sorry, but would you all go out in the hallway for a while and get to know each other? Call the meeting back to order, and continuing with the Peter Weirs matter, the chair continues to recognize Commissioner Feely.
Thank you, Mr. Chair. I move for a continuance so that the commission can take this matter under advisement and request additional materials from the requester, Mr. Weirs.
On the motion by Commissioner Feely, is there a second?
Second.
Seconded by Commissioner Lewis. All those in favor will signify by saying aye.
Aye.
Opposed? The ayes have it, the motion is carried. The chair was negligent at the beginning of this meeting. I'm only serving as chair today. I'm technically the vice chair. The chairman is in Pittsburgh and is on the telephone here and participating in the meeting. The next agenda item is McCormick, and that has been assigned to me, again, a lobbying opinion. And the facts pertaining to this advisory request are as follows. The requester is Tracy McCormick, Executive Director of the Retail Energy Supply Association, which I shall refer to as RESA. RESA is registered as a principal pursuant to the lobbying disclosure law. And RESA is hosting an upcoming energy symposium, which I shall refer to as the symposium, to educate its members and interested parties on various topics, such as the future of energy markets, product innovations, and enhancements to retail customers' shopping experience. RESA will invite certain state officials and employees to speak at the symposium regarding energy policy and regulation in the Commonwealth of Pennsylvania. RESA will invite a targeted list of state officials and employees to attend the symposium, and RESA is considering providing these state officials or employees a discounted rate of $25 for attendance at the symposium, as opposed to the rate of $200 that members of the general public would be required to pay. There is a reception following the symposium. Ms. McCormick asks whether the symposium would constitute lobbying, as that term is defined in Section 13A03 of the Lobbying Disclosure Law. She poses the following additional questions. If members of the general public would be charged $200 for attending the symposium, whether RESA would be permitted to provide state officials or employees a discounted rate of $25 for attending the symposium. Whether RESA would be required to report expenses associated with the symposium on its quarterly expense report, and if so, whether RESA's full cost of hosting the symposium or the difference between the general public and the discounted rate for state officials or employees would be a reportable expense. 3, whether RESA would be required to report staff time and expenses incurred in planning the event. And 4, whether reportable expenses should be reported as direct communication, indirect communication, gifts, or hospitality. At this point, I would pause to ask, is there anybody here from RESA that would like to address us and make a presentation? Okay, I see none. Mr. Chair, I have reviewed the facts and relevant statutory provisions, and I would like to make the following motion then. I would move that the holding of this commission in this matter be as follows. As a registered principal in Pennsylvania, RESA is subject to the prohibitions, restrictions, and requirements imposed upon principals by the Lobbying Disclosure Law. In hosting the symposium, RISA would be engaged in lobbying, and if the symposium would include one or more efforts to influence legislative action or administrative action in Pennsylvania through direct communication with state officials or employees speaking at or otherwise attending the symposium. 2, indirect communication, such as where attendees at the symposium would be encouraged to take action, the purpose or foreseeable effect of which would be to directly influence legislative action or administrative action. And or number 3, the provision of gifts, hospitality, transportation, or lodging to state officials or employees. As a registered lobbyist, or registered principal, RISA's provision of a discount rate to state officials or employees to attend the symposium would constitute lobbying and would be reportable as gifts and or hospitality provided to state officials or employees. The amount of the discount attributable to attendance at the symposium itself would be considered a gift, and any portion of the discount attributable to attendance at the reception would constitute hospitality. RISA would be required to report all lobbying expenses associated with the symposium on the appropriate quarterly expense reports. If the symposium would not include lobbying other than the provisions of gifts, hospitality, transportation, or lodging to state officials or employees, then RISA would be required to report the total costs of such as its lobbying costs for the symposium. If the symposium would include lobbying in the form of direct communication or indirect communication, the full cost of the symposium would be reportable. RISA's expense reports must include the total costs of all lobbying for the applicable period and allocate such total amount among the 3 breakout categories detailed in Section 13A05 of the Lobbying Disclosure Law. Discounts and any other gifts, hospitality, transportation, or lodging provided to state officials or employees to attend the symposium would be allocated to the category for reporting costs of gifts, hospitality, transportation, and lodging given to or provided to state officials or employees or their immediate families. Other costs of the symposium, including but not limited to RISA's staff time and expenses incurred in the planning of the symposium, would be reported as either direct or indirect communication. The primary goal of the Lobbying Disclosure Law is to ensure that all lobbying expenses are reported, and determination of whether a particular expense falls within direct or indirect communication is secondary. As long as it was, that was my motion. And there's a second from Commissioner Nick on the motion. All those in favor signify by saying aye.
Aye.
Opposed? The motion is carried and the opinion is approved. We now move on to administrative penalty orders and Judge Lewis. Commissioner Lewis, I'm sorry.
Mr. Chair, I just want to note I can recuse myself from one of these, all matters involving Keystone Research Center, 15-004-L.
Okay, for the record, Commissioner Feely has recused from the Keystone matter.
Thank you, Mr. Chairman. There are 9 administrative penalty cases with proposed consent agreements for our consideration. In 2 of the 9 cases, the parties have recommended a finding of no violation. In the case involving National Tax Sheltered Accounts Association, the parties have recommended a finding of no violation as to the alleged negligent failure of this principal to timely file a quarterly expense report for the second quarter of 2014. The reasoning proffered by the parties in support of their recommendation is that following a name change in January 2014, this principal filed a new registration statement and received a new registration number, and then subsequently filed a timely second quarter 2014 expense report under the new name and number. As an observation, it would seem that the appropriate way for this respondent to have proceeded would have been to amend its registration statement to reflect its name change rather than filing a new registration statement, or, failing that, to have terminated the prior registration statement once the new registration statement was filed. Because this respondent did not amend or terminate its prior registration statement, there appear to be two different entities when in fact there was only one entity. National Tax Sheltered Accounts Association has agreed to pay $500 to the commission representing a portion of the cost incurred in this case. That amount has not yet been paid. I will be making a motion to approve this consent agreement. In the next case, which involves Pennsylvania Associated Builders and Contractors, Inc., the parties have recommended a finding of no violation as to the alleged negligent failure of this principal to timely file a quarterly expense report for the third quarter of 2014. The reasoning proffered by the parties in support of their recommendation is that another principal that I shall discuss in a moment, namely Keystone Chapter Associated Builders and Contractors, Inc., included the lobbying expenses of both principals when it belatedly filed a quarterly expense report as the result of the commission proceeding initiated against it. Pennsylvania Associated Builders and Contractors, Inc. has agreed to pay $250 to the commission representing a portion of the cost incurred in this case. For the following reasons, I will be making a motion to reject the consent agreement in this case. First, according to the stipulation of findings, respondent did fail to meet its reporting obligations under lobbying disclosure law for the third quarter of 2014. Furthermore, the lobbying disclosure law and lobbying disclosure regulations would not permit this respondent to avoid its own expense reporting obligations by having another principal, namely Keystone Chapter Associated Builders and Contractors, Inc., include the lobbying expenses of both principals in the latter's expense report. These are two separate corporations that have registered separately. Except for a parent corporation and subsidiary that meet certain eligibility standards and register and report on a consolidated basis in accordance with the lobbying disclosure regulations at 51 PA Code Section 51.11, each principal's expense report must be filed separately to ensure accurate and complete disclosure under the lobbying disclosure law. As for the other 7 respondents, I will be making 2 motions due to the recusal of Commissioner Feely from the case involving Keystone Research Center. Each of these 7 respondents failed to timely file a quarterly expense report for the third quarter of 2014, and each has agreed to pay an administrative penalty. The amounts vary depending upon the agreed upon amount per day and the number of days the expense report was delinquent. The following 4 respondents would pay an administrative penalty of $3,185 each. Delaware County Solid Waste Authority. Second, Delaware River Waterfront Corporation. Third, O'Neill Properties. And fourth, Pediatric Dental Associates Limited. The other 3 respondents would pay administrative penalties in the following amounts. 1, Keystone Chapter Associated Builders and Contractors, Inc., $4,773. 2, Pennsylvania Golf Course Owners Association, $3,430. And 3, Keystone Research Center, $650. Each of the aforesaid 7 respondents for whom violations would be found has also agreed to pay an additional $250 payment to the commission representing a portion of the cost incurred by the commission in the matter. In each case, the parties are in agreement that the respondent's transgression of the lobbying disclosure law was negligent. Respondents, Delaware County Solid Waste Authority, Keystone Research Center, O'Neill Properties, Pediatric Dental Associates Limited, and Pennsylvania Golf Course Owners Association have already paid their agreed-upon administrative penalties and cost reimbursements and have filed their delinquent expense report. Keystone Chapter Associated Builders and Contractors, Inc. has filed a delinquent expense report but has not yet paid the administrative penalty and cost reimbursement. Delaware River Waterfront Corporation has not filed a delinquent expense report or paid the administrative penalty and cost reimbursement. Based upon my review, I would like to make the following 4 motions. Motion number 1. I move that this commission approve the consent agreement submitted by the Investigative Division and National Tax Sheltered Accounts Association, find no violation as to the allegation that this respondent negligently failed to timely file a quarterly expense report for the second quarter of 2014, and order National Tax Sheltered Accounts Association to pay the commission the agreed-upon cost reimbursement of $500. Motion number 2. I move this commission reject the consent agreement submitted by the Investigative Division and PA Associated Builders and Contractors, Inc., because according to the stipulated findings, this respondent failed to meet its expense reporting obligations for the third quarter of 2014, and because this respondent would not be permitted to avoid its own expense reporting obligations by having another principal report the expenses of both in the latter's expense report. The third motion, I move this commission approve the consent agreement submitted by the Investigative Division and each of the following respondents, order each respondent to pay the agreed upon cost reimbursement of $250 made payable to the Pennsylvania State Ethics Commission, and to impose the following administrative penalties for their delinquent expense reports for the third quarter of 2014. 1, as to Delaware County Solid Waste Authority, Delaware River Waterfront Corporation, O'Neill Properties, and Pediatric Dental Associates Limited, 1 administrative penalty each in the amount of $3,185. 2, as to Keystone Chapter Associated Builders and Contractors, Inc., 1 administrative penalty in the amount of $4,773. 3, as to Pennsylvania Golf Course Owners Association, 1 administrative penalty in the amount of $3,430. Finally, I move that those respondents who have not yet paid the administrative penalty or additional payment of $250, or who have not yet filed their delinquent quarterly expense report for the third quarter of 2014, are directed to do so within 30 days of the mailing date of the commission's order. Do you want to take these motions before we proceed to the motion where Commissioner Feely is going to recuse herself?
That might be the easiest. Is there objection to voting on all 3 of these motions at the same time? Chair hears no objection. On the 3 motions by Commissioner Lewis, is there a second?
Second.
Second by Commissioners Nick and DePalma. On the motion, on the motions, all those in favor signify by saying aye.
Aye.
Those opposed, no. The motions, all 3 of them, have carried unanimously. And for motion number 4, Commissioner Lewis.
Thank you, Chairman. Motion number 4, I move that this commission approve the consent agreement submitted by the Investigative Division and Keystone Research Center, and order Keystone Research Center to pay the agreed-upon reimbursement of $250 made payable to the Pennsylvania State Ethics Commission, and impose an administrative penalty in the amount of $650 for this respondent's delinquent expense report for the third quarter of 2014.
On the motion just made by Senator Lewis and Commissioner Feely, it is...
Don't make me senator.
Oh, did I say Senator? Yeah. I'm sorry. Hard to get rid of old habits. Made by Commissioner Lewis with Commissioner Feely recused from this motion. Is there a second?
A second.
Second by Commissioner DePalma. All those in favor signify by saying aye.
Aye.
Those opposed, no. The ayes have it, and the motion is carried. That concludes the administrative penalty orders. Moving to administrative matters, I don't know that we have anything under payment schedules, do we, Rob?
We had two items. One of the orders the Commission had issued last meeting involving Ray Talley, who was a former state official that the Commission found in violation. She made a substantial down payment toward the restitution she was ordered to pay and is on a $200 a month payment schedule for the balance, which I believe is a 2-year payment schedule.
Wow, that's good news.
And that really is the only one. We did have some, the orders that were issued, the S orders for the statements of financial interest penalties. At last meeting, we were in the process of having enforcement actions in Commonwealth Court on 13 different matters. The penalties were not paid. And the hearings begin sometime in, I think, around May 14th, and will continue toward the end of the month on different dates.
Are those hearings in Commonwealth Court like a pro forma motions, Judge? That would take very little time?
Yes.
That's okay. Thank you. Anything else under payment schedule?
That's it.
Okay, and now we have the public comment period that we have twice a year, once in Harrisburg, and that is today. Would anyone like to address this commission? Chair sees no interest. We have one final matter to take up because we have a very, very special guest in the audience today, a gentleman who has served many years on this commission and most recently as the chairman of this commission. And I would defer to the true chairman of this commission, Commissioner Nick Falafella in Pittsburgh. Nick, do you want to take over?
Thank you, Mark, very much. Listening to the meeting today, I felt like I was back on the House floor. And I just want to add one other thing. I hope Judge Lewis doesn't impose a $250 fine to me for not attending the meeting today, because she seems to be fining everybody.
Don't let that get around.
Well, first of all, let me just say, John, you are a remarkable individual. And I'm really sorry I couldn't be there in person today. I'll tell you, John, serving on the commission with you, I was just amazed by the leadership that you displayed whenever we had some problems with the General Assembly, and when we had to select an executive director. In both cases, I mean, you were outstanding, and I think that really led us to where we are today. I think we have an outstanding commission, and quite frankly, I think it's really because of you. And as the new chairman, I hope that I can do half as well as you did as a chairman. And I think what impressed us most about you as a member, as a commission, was, I mean, your commitment and your concern, your kindness, your attention to every detail, to every person's problems. And I think that's what impressed me the most, and I think that's probably what impressed all the members of the commission as well. And John, we're all honored to that you served on the commission, and we're very glad that we can just provide a little token of our appreciation to you today. Thank you, John.
Thank you, Nick. And I think that I've only been here a very short time with you, John, and I was amazed at your leadership too as the chairman. I look forward to it. I think it brought this commission through some difficult times, and it has become an excellent commission thanks to you and the way you worked with all of us who were sitting there. Thank you very much, John.
Mr. Bolger, on behalf of the commission and the staff of the commission, would like to present you with this plaque in honor and dedication of your years of tireless service to the commission.
Okay. I really appreciate it. Thank you very much. I got here and I walked in and they said, oh, you can't go in there. Oh, I said, oh, okay. I got in here and then sat down a little bit, waved at some of you, and they said, okay, now you have to leave. I thought, what did I do wrong? But seriously, I can't tell you how much, one, that I miss you all and the commission. And I thank you, Nick, and everybody for your kind remarks. And it was special serving with you, and you were all so supportive. I guess if I had a closing comment, maybe it would be advice or just my comments on your voting. I recommend that you do the right thing, not the concern of what your appointing authority wants you to do, not what the staff wants you to do, not what the commissioner on this next to you wants you to do. Do what you think is right, and you'll always be doing the right thing, and it'll make this commission even a stronger commission than it already is. You are doing a fine job, and Nick, so are you. And congratulations, and thank you very much for this plaque and for your support and friendship. I really, really appreciate it. Thank you.
Thank you.
Mr. Chairman, if I might, I'd just like to add my accolades to Chairman Bolger's record with the Ethics Commission, and personally thank him for, as a relatively new member of the Ethics Commission, having taken the time to sit down with me, actually took me to lunch, and we talked about many things, and he gave me great advice, so personal thanks.
Thank
Mr.
you.
Chair, I'd like to add to that as well. When I started on the commission, you did the same thing. You sat me down before I met everyone and kind of showed me the ropes, and that was very helpful, and I appreciate your guidance, and I really enjoyed working with you.
Thank you.
And I also would like to add my 2 cents, because since the chair has said I'm finding everyone, let me tell you what I find is that you have been absolutely a fine chairman and a fine commissioner and a fine gentleman and a public servant. I can only hope that we can emulate the example that you set, and you set a high bar as to what is expected in terms of the tremendous responsibility we have under the Act and the dedication and the commitment that we should bring to it by virtue of your example. And we are greatly, on behalf of all the citizens of the Commonwealth, and personally, since I was a new commissioner and you also oriented me, I want to thank you, and I want to say that I very, very much appreciated the time that I had to work with you.
Thank you very much.
And Mr. Chairman, I'd also like to, as the most recent new member of the commission, I'd like to echo what every other commissioner here has said, and thank you, John, for getting me started as well. Thank you.
Thank you very much. I really, really appreciate it.
And the chair would entertain a motion to adjourn.
So moved.
So moved by Commissioner Lewis, seconded by Commissioner Feely. All those in favor signify by saying aye. Opposed,
Aye.
no. The ayes have it. Meeting is adjourned.
See you.